what legal precedents did you put in front of the court for the H-1B visas? Those were filed multiple times by the employers.
So the motion to dismiss stage is the first of two stages in these types of cases. And the motion to dismiss stage is on really, really nerdy procedural lawyer stuff. And whether or not the employees had standing to sue and challenge an action that was taken based on the employer's conduct. And, we just pointed to the body of law that says you can challenge a government action that negatively impacts you, even if it's because of the actions of a third party. They weren't immigration cases, but we made analogies to those other cases. And we also just said, the Administrative Procedure Act is very clear. If you are an interested party and the only person that's interested in the cap number, as opposed to the petition's approval, is the foreign national. So they're the ones that have been impacted. And if you've been impacted, you can challenge a government agency action that's negatively affecting you. And those are really not controversial concepts, but the government's been fighting along those lines in each case. So I think we're on a good track for those other cases that are still out there. So one of the things that the government has been saying in court and defending themselves in court with is that they do not engage in secret fraud findings. This new policy that they came out with admits that they do, if you look at that paragraph 4 that we mentioned earlier. So we're restructuring the entire way we're doing these cases now and incorporating that into it, because that is really damaging information. And that's something we'll talk about more, the strategy that we've got for the upcoming lawsuit, in that webinar.